I wanted to invite Paul to come speak because this is timely right now. We've been battling Governor Brabanta for quite a long time, got many issues, whether it's pro-life, whether it's family-oriented. And Paul and Chuck have done a fantastic job at beating Newsom 10 times in a row now, probably 11 and 12, right? But they've done a great job. And this last case, I know we have in our presence Andrew Mirabelli, who's the husband of our clients, Elizabeth. And this was a huge case for California, but also for the nation. So I wanted Paul to come and talk about it, talk about the implications that it's going to have across the nation for our kids and for our for us as parents. So Paul has been with Chuck and Mary for 13 years here in Rancho Santa Fe. They have a private practice that they do medical malpractice and some other things, but they also do a lot of pro bono work with Thomas More Society for the religious liberty stuff. Paul has 8 kids, so he beat me and Tim, and they're just doing a great job. So here's Paul Jonna.
I invited a lot of friends because this is such an exciting and really historic case that I'm excited to talk to you guys about. But before I talk about the case, I do want to actually just recognize and thank Tim and Scott for all the work they do with this group. I mean, I think they've been, 12 years now, you said? You guys have been running this men's group. I mean, honestly, winning these cases is important, and the work that we do is really important, but the way we're going to be changing the world is groups like this, bringing souls to Christ. And so I do want to I think everyone should give a hand at Tim and Scott for all the work they do with this group. So before I talk about the case, I'm not going to make this a very boring legal discussion. I'm going to talk about what the case means. I'm going to talk about the evidence in the case, not really so much the law. And before we talk about that, though, I thought it would be helpful to just zoom out for a minute and reflect on a fact, which is that all of us recognize, and I think we talked about this earlier today in the chapel with Tim, that there are a lot of really serious problems in our society today, especially in California. And court cases are not going to be able to solve every problem. They can be effective in certain situations, but we know that a lot of the terrible policies that we see in California and throughout the country are just pure evil, period. And people with evil agendas can't really be convinced to do the right thing. There's no reasoning with them. So a lot of times they have to be forced. And the only lawful way to force bad actors to comply with the law is through litigation. And we've seen this in our practice, and, we had a number of cases during the pandemic that you guys may have heard about when they shut down churches. Even in, just looking back at that experience, there was a Supreme Court ruling out of New York that said that was unconstitutional, and we would have assumed that the state of California would have just recognized that and come into compliance, but it took our own separate case to force them to come into compliance. So, and then Tim alluded to this issue we had with, prayers to Aztec gods in schools. Demonic things that it literally took a lawsuit to stop. So, the other side could not be negotiated with. And so I think everybody here in this room recognizes that we're dealing really fundamentally with a spiritual battle. And we know that God is in control. He decides who wins and who loses these cases. And it's all for his greater glory. And something that we reflect on in our office and that we're always thinking about is that a common saying that you guys are familiar with is that we work as though everything depends on us, and we pray as though everything depends on God. And we're called to be faithful. We're not called to be successful. God decides who wins and loses. I was at a Bible study last night, and the Bible study teacher said something that really resonated with me. He said, God never promises to fix the mess. He uses the mess to fix us. And there's a lot of truth in that statement, and I could see in my own personal life how fighting these battles has helped strengthen my relationship with God, and how it's helped our clients who are directly in this mess grow closer to God. And I'm sure Andrew Mirabelli can relate to that. But when we win these cases, we're not just growing ourselves. We're also, by the grace of God, we are helping to fix the mess. And so that does help others as well. And in this case, what's so incredible and what's so special about it is that now it's a win for the entire country. So I was thinking I would tell you a little bit about how the case started. And I think it should inspire you to just reflect on how two ordinary people started a case that literally changed the law for the country and for a great good, and how God used these ordinary people to help good defeat evil. So a lot of public interest lawyers, you'll sometimes hear about like a case that I wouldn't say manufacture, but they have an idea about how they want to position a case to help change the law, and they look for a plaintiff. That's not what happened here. This is a completely organic case. Elizabeth Mirabelli and Lori West were two teachers in San Diego that learned about a new policy in their school. They filled out an online form with the Thomas More Society. They did not like what they learned about this new policy, and they wanted to talk to a lawyer. We got on the phone with them, we met with them, and they told us about this policy. They weren't trying to fix this for the whole country. They were trying to fix this for themselves. So this policy that started this case, essentially they found out for the first time, this is in 2022, that a kid as young as 5 in their school district, we found out it's actually as young as 2, can tell their teacher their gender identity and their new name, and the parents won't find out unless the kid consents. So, when we first heard about this, it was hard to believe. We didn't really, it didn't sound like anything we've heard of, and we couldn't imagine how something like that could be legal. But we looked at the policy, we looked at the website. I have some slides, so you guys don't have to hear me talk the whole time. But, okay, this is hard to read. But this is actually an excerpt from the California Department of Education website that was sent to every school district in the country. And it says, schools must consult with a transgender student to determine who can or will be informed of the student's transgender status, if anyone, including the student's family. With rare exceptions, schools are required to respect the limitations that a student places on the disclosure of their transgender status, including not sharing the information with the student's parents. So this went out to every school district in California, and it also attached model policies that they were told they had to adopt. In every school district, virtually every school district, rubber stamped the policies that the California Department of Education sent them. And so when Elizabeth Mirabelli found out about this, it was through trainings in her school like this one. And there's a question here, you might not be able to read it. It says, is a parent allowed to override a student's request for different pronouns and alternate names? And the answer is no. We shall use a student's preferred name and pronoun based upon student request. So if you're a Catholic teacher, a Christian teacher, a person who just understands common sense, you know how dangerous it is for a kid to adopt a new identity at school different from their biological sex. So this greatly troubled them, this greatly concerned them. And then, to top it all off, Elizabeth Mirabelli received an email like this. And if you guys can't see this, I'll tell you, this is an email that was sent out to teachers at this school district. This is actually for 7th grade. And it has a list of names of the students, their preferred pronouns, and whether or not the parents are aware. And if you notice, it's probably very hard to read, but for the first one, it says the preferred name is blank. The pronouns are he, it. This kid wanted to be referred to as an it. And so they got these emails, and they were blown away. They couldn't believe this was really happening. So we did some research. A lot of people at the time, just to back up a little bit, a lot of people tell us it's kind of pathetic that you even needed a case to deal with this. Like, this is so obviously wrong and so obviously crazy. But this was happening not just in California, not just in San Diego, but across the country. There's a real problem. And kids would start this social transition where they change their identity, and then they start a medical transition. And you guys have heard about these detransitioners, and we have some of those cases as well. We're representing Chloe Cole and other people who have made irreversible permanent changes as minors to their body, took sex-rejecting hormones, and really went down a very dark and dangerous path as minors, and then regretted it as adults. It starts at school, though, because the schools were facilitating this. It was all kind of a coordinated plan by very extreme activist groups. So this email is just one example from one school within one school district within San Diego, within the state of California. This was happening everywhere. Teachers were getting this. And by the way, why weren't teachers calling us? Why weren't we hearing about this from other people? Most teachers thought they had nothing they could do about it. They thought they had no choice. They got to do what the state of California tells them. I talked to family members who are teachers, and they knew about this, and they didn't think they had a choice. They thought they just had to follow whatever California says to do. But it took a brave person, Elizabeth Mirabelli, Lori West, to say, you know what? No, I'm not going to violate my faith. I'm not going to lie to parents. This is telling them to lie to parents. It says the parents are not aware. So please use their real name when you talk to them. They're being forced to actively deceive parents. So, it's one thing for me to say that. It's another thing for you to see proof of it. That's why I wanted to show you that slide. We took a look at the law. It was primarily my colleague Jeff and I, and there was no cases dealing with this, even though it was a nationwide phenomenon. But it was obviously so unconstitutional on so many levels, violates parents' rights, violates teachers' rights, violates common sense. And so we came up with a very clean and solid legal strategy. We spent a lot of time drafting a complaint. By the way, we found out this policy wasn't drafted by people in the California Department of Education. It was drafted by the National Center for Lesbian Rights and Equality California, and you name it. They draft this stuff. We saw the emails, and they send the policies to the state, and the state just puts them in the form policies that school districts adopt. Parents don't vote on them. Teachers don't find out about them. They just make their way into the handbook of policies that get sent to parents and teachers every year. No one sees them. But it wasn't until this training started where people were becoming aware of it. So anyway, just as some background about how this stuff percolates. So we filed this case in federal court on behalf of two teachers initially. And it was Elizabeth Mirabelli, Lori West. We got assigned to a really good judge Judge Benitez, which was great, by the way, but you can't just rely on having a good trial judge and say we're safe. You have to have a very solid legal theory that's going to withstand scrutiny at the higher courts. We knew this was going to be going up to the higher courts. So we've been through that road before, where you get a great trial judge and you're feeling really good and you get a good ruling and then it gets reversed. So I'll just say that because it helps a lot to have a good trial judge, but you need to correctly plead your case. Otherwise, it's going to get thrown out later. So we had a huge win in September of 2023. It was a preliminary injunction. Judge Benitez kind of 30-page ruling explaining in great detail for the country why this stuff is completely unconstitutional. I mean, it was so clear from this ruling, it should have just been the end of the case. We wrote them. We always do this because we want to make sure that when we ask for our fees at the end of the case, that we show the judge how many times we gave them outs that they refused. So in September 2023, we wrote them. We said, look, you guys have lost this case. You're going to continue to lose this case. The judge already said these are unconstitutional. You should withdraw all of these policies and settle this case right now. And they just ignored us, and that's fine. But just to give you an idea of what Judge Benitez said, this is from the conclusion of his order in September 2023. The school's policy is a trifecta of harm. It harms the child who needs parental guidance and possibly mental health intervention to determine if the incongruence is organic or whether it is the result of bullying, peer pressure, or a fleeting impulse. It harms the parents by depriving them of the long-recognized 14th Amendment right to care, guide, and make health care decisions for their children. And finally, it harms plaintiffs, who are the teachers, who are compelled to violate the parents' rights by forcing plaintiffs to conceal information they feel is critical for the welfare of their students, violating plaintiffs' religious beliefs. So instead of getting into compliance, though, and this is just to show you the mentality of how the state of California operates, instead of coming into compliance, what did they do? They ignored the ruling and they went on offense. They filed their own cases in state court trying to go after school districts that wanted to notify parents. So a lot of school districts found out about this ruling and they said, you know what? We're scrapping this policy and we're going to start notifying parents like we should. And Attorney General Bonta used taxpayer resources after receiving this ruling suing those school districts saying you're violating state law. Well, obviously, you don't need to be a lawyer to understand there's state law, there's federal law. If there's a conflict, I mean, federal law controls, but they were going after these school districts in state court, suing them, and then they'd get a ruling from a trial judge in state court, and then they would blast that ruling to every school district. And this is not, I don't expect you to read this, but this is an example. This was sent to every school district after our ruling came in and after he got these temporary wins in state court. And he would say, well, this federal court win, well, this just applies to 2 teachers. It really is very limited and narrow. And then he goes on to talk about his other state court wins. So basically completely deceiving every school, completely misrepresenting the law because what the judge said did not apply to 2 teachers. What the judge said applied to parents. The judge did a detailed analysis of how these policies violate parents' rights. So you have the top law enforcement officer of the state of California, top lawyer, the state of California, misrepresenting to every school district a federal court ruling. So it was clear to us at that point that we needed to rethink our strategy. So he was going to ignore the ruling. Basically what that means is he was only applying it to the 2 teachers who sued. I have a lot of class action experience doing federal securities class actions before I started doing this work. So I thought, you know what, why can't we have a class action here? So we amended the complaint, we added parents, we added teachers, and we said it's a statewide class action. You can't ignore that. And we asked the judge, there's no need for discovery, just grant summary judgment. You already did the analysis, grant class certification, grant summary judgment, but the other side protested, no, we need discovery. So we took 26 depositions, all of their experts, and they filed 8 or 9 motions to dismiss the case. They lost every single one, and the judge eventually did certify it as a class action. By the way, I should mention one of the parents that we added they were all, because of, kind of getting ahead of myself, but because of Elizabeth and Lori filing this publicly, they suffered severe and devastating retaliation and discrimination and harassment at their schools. So they stood up for everybody. They stood up for themselves and for everybody. They were forced out of careers they loved. These are teachers of the year, phenomenal teachers, 30-year records. And I'll show you some pictures of what happened. But to make a long story short, after seeing that, everyone else that joined with a pseudonym, which is like a Jane Doe or John Poe. So we have 2 parent groups, and it's the Poes and the Does. And just to tell you about how tragically sad the story is of the Poe family, just to give you an example of how we wanted parents that we could show the court how real world examples of how these policies affected real families. And so the Poe family, amazing Catholic family, both parents are Catholic, both parents groups, the Poes and the Does. But the Poe family, they had a daughter who was having some difficulties with her gender identity, okay? During COVID, this was very common. A lot of kids were manipulated through social media, and she had some questions about her gender identity. Her parents knew she had concerns about things generally. They had no idea that at school she was using a new name and new pronouns. They had no clue. And they didn't find out until after her suicide attempt. The doctors told her in the hospital, by the way, did you know that she's going by this male name at school? And of course, they had no idea. Their daughter almost took her own life. They were about to lose her. They could not get her the help she needed because they were kept in the dark. And Judge Benitez would frequently say at these hearings when he's asking the attorneys for the state of California, who's going to be there at the hospital bed when they're dying? Is Rob Bonta going to be there? And he would say that to them, and they had no answer, because of course not. It's going to be the parents. Why would you exclude the people who are going to suffer the most and who care about this person the most? So anyway, I just wanted you to know after the parents found out, they got their daughter the help she needed, and she's doing much better. But the school, even after that, the school refused to honor the parents' request to call her by her birth name. And that all changed now. But I'm just saying, even after her suicide attempt, the school was calling her by a male name and male pronouns. So this is what was happening. That was just one example. I do want to show you, these pictures don't do any justice for what happened to Elizabeth and Lori, but just to give you an idea, these are veteran teachers working right here in Escondido. They come to school and this is okay, you can't tell what any of this stuff says or means, but I'll just summarize it. So this video of the kids with their faces blacked out, a teacher organized a protest video at school where they got the rainbow flags and they started making a video that they circulated to everyone in school. That doesn't sound like a big deal, but if you're a teacher, I mean, this is an attack on your dignity, attack on your reputation. It was sent to everybody, not just students, teachers. They were mocking them. They were putting hate posters all over their classrooms. They had no choice but to leave. It even got physically threatening at some points. So they were ran out of their school for standing up for their faith. There was a protest organized, so they would send these, and no one's saying you can't disagree with their position, but it wasn't just disagreement. It was harassment, it was intimidation, and it was retaliation. And then they put them on leave, and then it became failure to accommodate, and they have active claims against that school district today. I just wanted you to know about this because Andrew, the husband of Elizabeth, who's here right now, if you want to stand up, Andrew, so everyone knows, he. Thank you for being here, Andrew. But their life was turned upside down, and I've walked through with them through this process, and it's still not over. But anyway, I just wanted you to know this is not easy. This process. So anyway, when their experts came for deposition, it was two experts that we literally read everything they ever wrote ever about the subject. And every book, every article, every blog that their experts wrote. And honestly, I could do a long talk. Just you guys would, it would be hilarious to see and hear the stuff that these people said. And they were totally and utterly discredited. They actually made so many concessions because this stuff is so circular and so nonsensical that they actually became our experts. And in fact, on all the main points, the judge cited them to support our positions because who can dispute them? I mean, obviously they had to concede kids are going to do better if their parents are supportive and informed. Obviously they had to concede that a kid having two identities, one at school and one at home, is going to be very harmful. And these are all common sense points. You don't need to be a doctor or an expert to realize them. But just to give you an example of how nutty these people were, this is the stuff we found on Darlene Tando's blog, and I'm sure you can't read it, but it says, some people are born with boy bodies and have the hearts and brains of girls. Some people are born with girl bodies and have the hearts and brains of boys. And then they have this worksheet where you figure out what heart you have and what brain you have. And try to make sense of this. This is something that we found that Darlene Tando wrote. She says, right here, like towards the middle, it says, one of my kiddos, this is, we actually transcribed a speech she gave. One of my kiddos, designated female, that means she was a girl, identified as male. And this kiddo had a very feminine, authentic gender expression. So just stop there. This is all nonsense, by the way, but she's saying this is a biological female who thinks she's a boy, but she had a feminine gender expression. So what that means is she presents to the world as a female, but she inside thinks she's a boy, okay? However, he knew that if he were to act upon his authentic gender expression, meaning nail polish, skirts, purses, earrings, that he would be misgendered because he would look like a girl. And anyway, I mean, this stuff is so nutty, and we were able to poke so many holes in their reasoning, and the expert depositions were actually a lot of fun. In fact, when we told the judge we had a motion to strike them as experts, and the judge was so intrigued by the deposition testimony that he asked for the videotapes. He wanted to see how these people testified, and so we provided those to him, and he issued a really, his opinions, if you guys are ever interested, extensively cite all the contradictory and ridiculous positions that they took. So eventually, Judge Benitez, actually, before we get to that, we also, because they would frequently lie and misrepresent and deceive the court, they made this argument, the state of California. They said, Your Honor, we took down that page. Remember that page I showed you that said the policy for the state of California? Well, they said, we took down that page, Your Honor, so the case is moot. Dismiss the case. And of course, we knew the case wasn't moot because every school district already had that policy on the books, and they were suing the school districts that didn't. And on top of that, we found out later that in a secret password protected training they were sending to every teacher in the state of California called PRISM, you may have heard of it, they had the same policy spelled out in black and white that they say they told the judge they took down. He was very close to sanctioning them, and they were very fortunate that he didn't, but he ordered the Attorney General to appear in court. The Attorney General didn't appear. And anyway, this all just painted the picture. And the Supreme Court later, I'll get to that, later cited a lot of this because these guys thought they could outsmart a federal judge and a pretty smart legal team. And with their $1.6 billion budget, I was amazed at how poorly they made the case was just impossible to defend. But on top of that, they just had very, very bad strategic decisions. They lost all credibility with the courts. And it really undermined their position. So anyway, in December of 2025, not that long ago, Judge Benitez issued a class-wide permanent injunction. So what that means is instead of that first one that he issued that was just for the 2 teachers, this one now is for all teachers in the state who objected to the policies and all parents in the state who objected to the policies. So we kind of put the state in a tough position because now they can't ignore that. They need to do an emergency appeal if they want to stop that. Otherwise, they should just accept the reality that these policies are gone. So, and then this is just a quote of some of the provisions of the injunction. It says you can't require any employee, this is what Judge Benitez wrote, any employee in the state education system to mislead or the parent or guardian of a child. You can't directly lie to them. You can't prevent the parent from accessing educational records of the child. And you can't use different sets of pronouns and names when speaking with the parents than it's being used at school. And you can't require employees to use a name or pronoun to refer to the child that don't match their legal name and natal pronouns where the parents object. And on top of that, he said you have to post this notice everywhere in your gender-related materials that says parents and guardians have a federal constitutional right to be informed if their public school child expresses gender incongruence. Teachers and school staff have a federal constitutional right to accurately inform the parent or guardian of their student when the student expresses gender incongruence. These federal constitutional rights, in case they didn't know this from law school, are superior to any state or local laws, state or local regulations, or state or local policies to the contrary. So with this order, which was issued December 22nd, 2025, we said this is the perfect Christmas gift. We were so excited. And then, lo and behold, the Attorney General files an emergency request for a stay on Christmas Eve. And so our team was working around the clock trying to oppose that. And the Ninth Circuit, a 3-judge panel, they first issued an administrative stay, which is very, it doesn't really reflect their final decision. And then on, in early January, in a detailed opinion, they actually issued a stay of the entire injunction. And it was a very, let's just say, the reasoning was very out there. The Supreme Court, the Ninth Circuit completely misapplied controlling Supreme Court authority. They completely, rejected pretty much every major point that Judge Benitez made. So it was a complete reversal. Terrible ruling, but it was so bad and it was so out there that it gave us the perfect vehicle to now ask the Supreme Court to take a look at what happened. Because if they had kind of split the baby, or if they tried to do something a little bit sneakier with leaving some things in and other things out, but they just rejected the whole injunction, and they stayed it during the pendency of the appeal, which if that lasted, it would mean that this injunction basically doesn't exist while the appeal's ongoing. They keep on doing their thing. They keep on hiding this information from parents. So, I mean, what I've said to people is the devil always overplays his hand. And in this case, the Attorney General really did overplay their hand because they were in a tough spot. They either accept this ruling or they do an emergency appeal. They did the emergency appeal. The Ninth Circuit gave them what they wanted. They felt very happy. We immediately filed an emergency application with the U.S. Supreme Court. And at the time, there were several cases knocking at the Supreme Court's door with this issue. The problem was a lot of those cases, and not to get into too much of the legal weeds, but a lot of those cases didn't have the records that we had. They didn't have the developed record with all the depositions, with the experts. They didn't have a First Amendment claim for parents. A lot of them relied on a 14th Amendment claim only, which is a good claim, but they did not have a lot of important aspects that made this a good vehicle. So we were kind of nervous that the Supreme Court was going to take one of these other, or not take one of these other cases, and that would affect the future of this issue. But fortunately, because of what the Attorney General did, we were kind of able to skip the line ahead of all of those cases and ask the Supreme Court to undo what the Ninth Circuit did. And after 8 weeks of waiting, the Supreme Court, by the grace of God, on March 2nd, issued an order not only vacating the Ninth Circuit stay, but explaining in some detail, which is kind of rare for these emergency applications, explaining in some detail why they were vacating it. And it was a groundbreaking decision. And I'll just, I'm not going to read the whole thing to you, but there's quotes in here that are so significant. They refer to the intrusion on parents' free exercise rights. They explain, there's this really not, again, I said I wouldn't talk about the law, but there's this really important case called Mahmoud, which established reaffirmed the longstanding point that you can't interfere with a parent's First Amendment right to direct the religious upbringing of their kids. And in the Mahmoud case, it dealt with storybooks that were being read at school that dealt with LGBT storybooks. And the parents said, we don't want our kids reading those. We want to opt out. And the Supreme Court said, yeah, you have the right to do that. And it was the Mahmoud case. But we said, Your Honor, this is so much more egregious than books. They're allowing the kids to socially transition in secret. Parents have to have a First Amendment right to opt out of that. And the Ninth Circuit said, no. The thing in Mahmoud, that was way worse with the books. This is nothing compared to that. I mean, basically, they had a narrow application of Mahmoud. And the Supreme Court, very clear, this is going to be major for the nation. They said, no, Mahmoud should not be read narrowly. Every court in the country has to know that was an important decision. So this case reestablished that. But anyway, they also said, under long-established precedent, parents, not the state, have primary authority with respect to the upbringing and education. The rights protected by these precedents includes the right not to be shut out of participation in decisions regarding their child's mental health. And it also says that we had standing, which was also being challenged. And it says that class certification was proper, which is a big deal, by the way, because this is one of the very few that we know of religious liberty class actions. And there's already courts citing this case for that purpose. So it's it was a unique idea, and honestly, Judge Benitez correctly certified it as a class, but it was a pretty important component of the case. So basically, let me talk a little bit very briefly about. There's a lot more I could quote from the case, but you guys don't want to read a court decision right now. So, what is the impact of this case? So obviously, practically speaking, every school district in the country that has these policies, and we know they're nationwide, they're unconstitutional now. The Supreme Court said they violate parents' First Amendment rights and parents' 14th Amendment rights. And so every school district that has these now has to take them off the books. The schools cannot facilitate a social transition without parents' knowledge. Schools have to provide notice to parents if their kid expresses gender incongruence, and an opportunity to, they have to get the parents' consent. If the parents object, they have to follow the parents' wishes now. That's what this case has established. It also, like I said, rejected that narrow reading of that really important case, Mahmoud, and it also, there's also quite a lot of people speculating about how it's going to be used to expand parents' rights in other contexts, including, I'm not sure if you guys realize this, but a minor has the right currently to get an abortion without their parents' knowledge. And that's been, there's been, so this, I think this ruling will also sort of help, undo that whole, there's a lot of cases dealing with that, and so this will be used in that way too. The judge also recently issued a large fee award, for the time and expense it took. Actually, and it's good because it sends a message to every school district in the country, every state that tries to violate someone's fundamental constitutional rights. There's going to be a price to pay. The ultimate fee award was $4.8 million, and that's not even counting the appellate fees. And a lot of that money will go back to the Thomas More Society to rebuild the war chest. But it should hopefully be a strong deterrent. And unfortunately, the case is not over. There's still fighting it. They asked the Ninth Circuit to reverse the Supreme Court, basically, in a recent motion that they filed. The Ninth Circuit did not want to do that, so they said no. So we're still on appeal, but the writing is on the wall. The reason we're still on appeal is because it was done on an emergency basis, and the Supreme Court, in lifting that Ninth Circuit stay, the Supreme Court said, we're likely going to win this case, and here's the reasons why. And they're not going to change their mind when this appeal is over. So it should really, hopefully, force them to just drop this issue and settle the case. But we're not going to be expecting that to happen anytime soon. So we're still fighting them. But I think this might be a good time to take questions. I kind of went on for a while there. So thank you, guys.